Good evening, Sunita. Thank you for that kind introduction. And I will get straight into the topic for today. So friends, today I've been requested to speak on judicial activism or judicial overreach. And I wanted to talk about this and give an Indian perspective of how Indian courts have been judicially active and what is the distinction between judicial activism and judicial overreach. But before that, before I get into that particular subject, it is necessary for me to just give a sort of a background on this particular topic so that we are better able to appreciate the context in which I'm going to be giving my talk today. Friends, firstly, you have to appreciate that the courts in India and particularly the higher courts, such as the Supreme Court of India and the various high courts in the country, have over the period of time played a very important corrective role, or if I may say, a very, very salutary role on innumerable occasions, and that is primarily to protect the fundamental rights that are enshrined in our Constitution. Now, as you know, the fundamental rights are enshrined in Part 3 of the Constitution. Our draftsmen, our forefathers who drafted the Constitution thought it fit to guarantee us certain fundamental rights. Now, it is the interpretation of these particular rights, the manner in which these rights have been upheld, the way they have been molded, the way these rights have been interpreted to ultimately give them some meaning, to give them some teeth, is really what is important, or is really the important role that the higher courts, that is the High Court and the Supreme Court, have played in independent India. It's one thing to have your right guaranteed in a constitutional document, but it is another thing where the courts actually uphold these rights, mold it, and give that particular relief to that litigant or to the citizen who invokes these jurisdictions, these plenary powers of the higher courts to have their fundamental rights protected. Having said this, it's very important to understand that there is a very thin line between judicial activism and judicial overreach. Now, as you all know, as students of law or lawyers in general, that essentially we have under our constitutional framework what is called doctrine of separation of powers. So a government is essentially made up of three organs, that is the legislature, the executive, and the judiciary. Each of them within the constitutional framework is expected to work within its domain, within the parameters that are set. And if they function in the manner that they are required to, then obviously there is no transgression of any of the organs in respect to the powers that are to be exercised by each of the organs. However, more often than not, that does not happen. In fact, there is a growing dissatisfaction regarding the functioning of the legislature. There is a growing dissatisfaction regarding the functioning of the executive. People feel that there lacks a certain degree of governance. There is a lack of ability to effectively govern the citizens, and therefore the citizens invoke these plenary powers and approach either the high courts at the state level or the Supreme Court, complaining about all these infractions of fundamental rights or whatever their topics may be. And the more we see that the people start approaching the higher courts in the capacity of judicial review against executive action, against legislative action, that is where the judiciary starts stepping in, and the judiciary examines the problem that is brought before it and then decides whether it is within the constitutional framework or whether it is beyond the constitutional framework. In that sense, therefore, the judiciary is placed in a rather unique position, because it is only the judiciary and the judiciary alone within our constitutional framework that can examine a legislative action. If a particular legislation passed by the parliament is contrary to the constitutional principles, then the higher courts and the Supreme Court have the ability to judicially review that particular legislation and strike it down. Therefore, the wisdom of the legislature can be intervened by the judiciary, and the judiciary can say that no, this does not fall in consonance with the constitutional principles, and therefore we will strike this particular legislation down. Similarly, executive action. If an executive action is without authority of law, transgresses the basic constitutional norms, then certainly the judiciary will step in and will again correct the breach that has been committed by the executive. So in that sense, of the three organs, namely the legislature, executive, and the judiciary is the only organ that is empowered to examine the performance, if I may say so, of the legislature and the performance of the executive. The same is not permissible in the reverse. In other words, the legislature and executive do not have that particular luxury. Having said this, this does not in any manner mean that the judiciary is a supreme organ, or is an organ, or is a body which is above the legislature, or which is a body which is above the executive. What it only means is essentially that the constitutional framers thought it fit to give judiciary this particular power so that there is an inherent system of checks and balances. In other words, the courts are expected to see whether a legislative action, whether an executive action is in conformity with the constitutional framework. If it is, it allows it to take place. If it does not, it intervenes and remedies or corrects that particular breach. That's about it. And therefore, it's a system of checks and balances that has been evolved over a period of time. Now, this power of the courts, especially the higher courts, to examine the judicial action, legislative action, executive action, is what we essentially call the power of judicial review. You must have heard this term, judicial review of legislative action, judicial review of administrative action, judicial review of executive action. What is this? This is ultimately when the court examines the exercise of the authority by the legislature, by the executive. Now, the Supreme Court, the Constitution provides the Supreme Court with the power under Article 32. It's a plenary power. The High Courts are vested with powers under Article 226. That again is a plenary power. You all know about the different kind of writs that are issued from time to time against infractions made by the state or its instrumentalities if they affect any of the rights guaranteed under Part 3 of the Constitution. So this power of judicial review is itself a constitutional provision, is itself a basic structure of our Constitution, which makes the judiciary, or which rather puts the judiciary in this particular unique position. Now, judicial review can be of two types. One is a pretty straightforward form of judicial review, wherein matters come in from the lower courts or the hierarchy of courts or special legislations, where there are orders, decrees, sentences that is examined in a court of appeal, that is further examined in the High Court, and then onwards in the Supreme Court. Either you affirm it, you modify it, you annul it, you reverse it. This is typical judicial review of proceedings that emanate from the lowest court as as per the hierarchy that is provided in our constitutional framework. It is, however, judicial review of executive action and judicial review of legislative action that becomes more controversial and more contentious. Now, why does it become more controversial or more contentious? Is because there is an inherent feeling amongst the legislature or the executive that the third organ of the government is now transgressing into our domain or is transgressing into our business. And when that happens, there is bound to be some degree of friction. Therefore, I said, to begin with, as to what is judicial activism and what is judicial overreach is a very thin line. And this you will be able to appreciate as the talk progresses, because I'm going to share some important landmark cases which, according to me, contributed to the evolution of judicial activism in this particular, in our country. Now, to begin with, I mentioned to you all that why is this happening? This is happening because, frankly, the people feel that judiciary in that sense is the last bastion. It's the sentinel of its fundamental rights which are enshrined in the Constitution. Day in and day out, there is always a sort of a tryst with the administration, with the executive, with the legislature. If there is some legislation, some group of people will challenge that particular legislation. Maybe it's a legislation pertaining to disqualification. Maybe it's a legislation pertaining to beef ban. If you all would recall, there was a big hue and cry in the first part of the current government when they came about with this particular legislation. So that legislation was challenged. Then there are various executive orders that are passed on a day-to-day basis, which are again arbitrary, and therefore we lawyers draft it in a manner so as to bring it within the mischief of Article 14 of the Constitution, read with any of the articles, sub-articles of Article 19 or Article 21, which in that sense is a plenary article. So, because of this constant, if I may say so, tryst with the legislature and the executive, people keep running to the judiciary. It is we lawyers who make elaborate arguments. It is we lawyers who draft petitions, basis, of course, the instructions from the client. And that is what comes before the court. And when that comes before the court, the natural reaction of the judiciary is that we must uphold the right of a citizen, because the citizen's right is of prime importance. And if it is fighting against the might of a state, then naturally you must yield to the right of a citizen rather than the might of a state. So that is where, if I may say, the seeds of judicial activism were sown. And that's how judicial activism in contemporary India started. Friends, to begin, judicial activism is in that sense, as I indicated, will be more appositely mentioned to you, or more appositely explained once I take you through certain cases. So you will get an idea of what I mean by judicial activism. But before we progress to the next topic of discussion, before we progress in this particular talk, there are two quotes that I would like to read. And the reason I would like to read this is because one is from a former Prime Minister of the country. So in that sense, the head of the executive. And one from a former Chief Justice of India. So in that sense, the head of the judiciary. And if you see these two statements made by them, you will appreciate the friction, the business of judicial activism and judicial overreach, how it is viewed by one organ of the state as compared to the other organ of the state. To begin with, I would like to read a small quote. This was sometime in the year 2007 by the then Prime Minister, Dr. Manmohan Singh. He said, and I quote, "Courts have played a salutary and corrective role in innumerable instances. They are highly respected by our people for that. At the same time, the dividing line between judicial activism and judicial overreach is a thin one. There is a growing dissatisfaction regarding the functioning of the executive and the legislature and their ability to deliver effective governance to meet the needs and challenges of our times. In this background, it is a matter of great satisfaction that the public at large continues to hold our judiciary in high esteem. The judiciary, as custodians and watchdogs of the fundamental rights of our people, has discharged its responsibility very well indeed." So this is what a Prime Minister of our country said. Per contra, Chief Justice Dr. A.S. Anand, former Chief Justice of India, Supreme Court of India, and former Chairperson of the Human Rights Commission, while addressing a gathering pertaining to judicial overreach and judicial activism, quoted thus, and I'm quoting, "The legislature, the executive, and the judiciary are three coordinate organs of the state. All three are bound by the Constitution. The ministers representing the executive, the elected candidates as members of parliament representing the legislature, and the judges of the Supreme Court and the High Court representing the judiciary have all to take oaths prescribed by the third schedule of the Constitution. All of them swear to be true faith and allegiance to the Constitution of India. When it is said, therefore, the judiciary is the guardian of the Constitution, it is not implied that the legislature and the executive are not equally to guard the Constitution. For progress of the nation, however, it is imperative that all three wings of the state function in complete harmony. That is the real test. So long as all three organs are functioning in complete harmony, there is no difficulty. Once there is disharmony, once there is a disconnect, then the judiciary is bound to step in, because that is what is expected of the judiciary. Today, however, apart from the basic judicial review concept, the courts are not just satisfying themselves with whether a particular thing is right or wrong. Courts in India today are not remaining passive anymore. They are not confining their role in striking down legislative or executive functions or decisions. They are going a step further. One notices that there is a new approach, and that approach seems to be more towards affirmative remedial actions, and by issuing writs, orders, and directions to this particular end. So therefore, it is gone are those days when the court would simply exercise the power of judicial review and examine whether an action is within the constitutional framework, either ultra vires or intra vires the Constitution, and decide a matter. Today, they are going a step further. In fact, there are certain cases where the courts are even, if I may say so, embarking upon legislation. They have virtually found that there is a vacuum on a particular subject. So while they hope that the parliament would legislate on that particular subject, since it is an unoccupied field, the Supreme Court decides that in the interregnum, these will be the directions that everyone will have to follow in this particular country, and that becomes the law of the land. Now, this, as I said earlier, this is because of the general belief that there is an abject failure on part of the administration, on part of the legislature and executive to effectively govern, and therefore the people repose faith in the highest court of the land of the state. But this is not, judicial activism is not something that is happening today, or is not something that has evolved over the last 10 or 15 years. if one examines the constitutional history, and if you see constitutional jurisprudence in this regard, it's very fascinating, because if you read judgments prior to 1977 and post 1977, you will find that there is a paradigm shift in the approach of the Supreme Court. Now, why is this 77 so important? Because those were the 75, 77 was the emergency era. So a lot of excesses happened by the state, which were questioned in the court of law. And that's when the court started approaching problems of the citizens from a slightly different perspective. Earlier there too, the approach of the Supreme Court was slightly different. Now, judicial activism, ultimately, what is it? In its heart, in its essence, a judicial activism means that the court must come to the rescue of the downtrodden, of the disadvantaged groups of our country, who are not able to fight the might of the state. And there is a desire, or if I may say, an intention of the judiciary to do something for these have-nots, to do something in such a manner that their rights are protected, their rights, which are fundamental rights, falling in Part 3 of the Constitution, are protected. And therefore, we find that of late, about 20 odd years ago, perhaps a little more, the advent of public interest litigation started. I'll come to that aspect a little bit later. But before that, on the evolution of judicial activism, I wanted to just highlight or just touch upon certain cases which, according to me, are relevant and are important. Now, if one sees the constitutional jurisprudence, way back, even prior to the 1965s and 1967s, the Supreme Court was examining the issue of the power to amend the Constitution with reference to Article 368. And that was in the case of Shankari Prasad. Supreme Court there at that time upheld that the Parliament had unfettered right, or the legislature had unfettered right under Article 368 to alter the fundamental rights that are guaranteed under the Constitution, guaranteed under Part 3 of the Constitution. That view was starting to change 2-3 years down the line when the case of Sajjan Singh came up to the Supreme Court. Because in Sajjan Singh versus State of Rajasthan, the Supreme Court took a contrary view. And although it upheld the view of Shankari Prasad, which means the legislature is competent to amend Part 3 of the Constitution by virtue of Article 368, the dissenting opinion of the two learned judges in Sajjan Singh's case, that is of Justice Budolkar and Justice Hidayatullah, they dissented from that particular view. And that's what was, if I may say, the basis of the basic structure doctrine as we understand it in today's in constitutional jurisprudence. Of course, after that, there was a struggle for supremacy between the legislature and the judiciary. And that ultimately culminated in the decision in 1967 in A.K. Golaknath versus State of Punjab, where the Supreme Court eventually held that Parliament does not have the power to amend the fundamental rights because that would be affecting the basic structure doctrine. So that's how a different view was taken in Golaknath's case. Eventually, of course, that struggle went on for some time, and it was ultimately the famous judgment or case of Kesavanda Bharti, which the learned 13 judges of the Supreme Court in its historical 66 days of hearing ultimately laid down the foundation or the basis of our constitutional jurisprudence, wherein they held that in our constitutional law, the axiom that Parliament cannot by an amendment to the Constitution alter the basic structure of the Constitution was laid down in Kesavanda Bharti's case. Now, why am I mentioning so much about it? Because if one does read Kesavanda Bharti in great detail, one will realize that the government of that time, there was virtually a tussle between the government of that time, which enjoyed a brute majority, and the judiciary. Somehow, the government of that time felt that the judiciary was transgressing too much into the power of the legislature and the executive, and that was referred to by the government of that time as judicial overreach. Well, was it welcome? Yes, it is welcome, because that is a fundamental right that was protected by the Supreme Court in favor of the citizens. Now, in fact, even after the Kesavanda Bharti's case, every attempt was made by the government at that time to see to it that that judgment is reversed. In fact, there was a review petition filed. Somehow that review petition died its natural death. So much was the animosity at that particular time between the government and the Supreme Court or the judiciary, that on the day, that is on 24th of April 1973, the day when the judgment was being delivered, that was the last day of Justice Sikri, who was the Chief Justice of India. So they had to deliver the judgment on that particular day. The judges, who were three senior most judges after Justice Sikri, were actually superseded because they gave a decision against the government. And Justice A.N. Ray was appointed as the Chief Justice because he had actually held in favor of the government. This was the nature of the tussle between the judiciary and the Parliament at that time. In fact, later, after this review attempt failed, the Parliament came about with the 42nd Amendment on 18th December 1976, during the emergency, that is, to amend Article 368 itself, wherein the amendment sought to give power to amend fundamental rights. It so happened that that particular amendment was not challenged till much after, till almost, if I'm not mistaken, 1980, when eventually, I think Chief Justice of India at that time was Justice Y.V. Chandrachud. He was heading the bench, and this particular problem cropped up in Minerva Mills case, wherein ultimately 42nd Amendment was considered, and the Supreme Court said that nothing doing. The basic structure, the 42nd Amendment itself is violative of the Basic Structure Doctrine, and therefore it was struck down. So after that particular judgment, this debate between the power of the legislature to amend the Constitution dramatically, and that too with reference to Part 3 of the Constitution, was set at naught. And they said that if it violates the Basic Structure Doctrine, then Parliament has no particular power. So now you see that this was Sajjan Singh, Golaknath, Kesavanda Bharti. Now the government of that time had the famous slogan that was Mrs. Indira Gandhi's government. It was a very socialist government in its approach. It had the slogan Garibi Hatao was the main slogan. So towards that end, towards that policy of the government, which could be well lauded at that particular point of time, because that was the wisdom of the people we had elected into Parliament, that only socialism could help India in those circumstances, because we were a poor nation. Our industrial output was abysmally low. There was poverty, and there were all kinds of problems. So Garibi Hatao was the slogan. Now towards that end, a lot of socialist legislations came. In fact, one would recall that in 1970 there was the bank nationalization case, which is R.C. Cooper versus Union of India. That case, the Banking Act was challenged primarily on the ground of unreasonable restriction imposed on a bank to carry on non-banking business, in effect making it impossible for banks to function in a commercial space or in a commercial sense. Then there were other cases which were dealt with during that particular emergency time. And one of the most telling case was that of ADM Jabalpur. Now, in the case of ADM Jabalpur, one would recall that that was during the time of the emergency. The Supreme Court held in that particular case that a detainee under a preventive detention did not have a common law right to secure his release from an arbitrary detention, even if it was passed without authority of law, by approaching a court of law. Why? Because the fact that there was an emergency declared, your very right to approach a particular court stood suspended during the emergency. This was upheld by the Supreme Court. There was a great deal of criticism about this judgment. There was complete uproar amongst the highest echelons of the legal luminaries. And after that judgment of ADM Jabalpur, which was sometime in 1976, you will find that the approach of the Supreme Court changes dramatically in cases of rights of citizens. Then in 1980, if you would recall, there was that famous Bhagalpur blinding case, where the Supreme Court held that Article 21 included within its sweep right to legal aid to the poor and the indigent to be represented in a court of law by a lawyer. So Article 21 was taken to a different level. Then sometime later, Maneka Gandhi versus Union of India. Maneka Gandhi's passport was impounded by the government of that time. The Supreme Court said Article 21 is not just mere animal existence. Right to live, right to liberty would also move within its sweep. A right to freely move about. The concept of substantive due process was imported in Article 21. Therefore, my friends, if you read the constitutional history and if you read judgments from 1976 onwards, you will find that there was a lot of judicial activism happening. There was a lot of judicial activism happening, and it was happening in aid and for the benefit of the citizens to uphold, to mold their fundamental rights, which we also cherish till this particular date. Had it not been for this judicial activism, one doesn't know. We would have had a totalitarian state. So, judicial activism has its plus points also, and therefore, as I said, it's a very thin line to tread on. But at the same time, all judicial activism is not something that is welcome, and I'll come to that a little later. So, judicial activism was something that it started evolving, you can say, post the emergency area, and I just gave you a few cases so that you appreciate it in that particular perspective. However, if you look at the more recent times of the Supreme Court and the more recent case law on this, one sees that the Supreme Court has widened its approach in matters of public administration, in matters of policy decisions of the government, largely in matters, in environmental matters. And if one looks at the judgments from time to time, you will see that a lot of the cases which are, as I mentioned some time back, public interest litigation, a lot of these cases engaged the Supreme Court through the phenomena, if I may use the word, the phenomena of public interest litigation. In fact, the Supreme Court, while entertaining public interest litigations, as you may know, even entertained a postcard of a détenu in a jail as a public interest litigation. The locus standi doctrine was completely watered down. It's not that how are you affected? You could be representing a body of individuals. You could say that I'm a ratepayer, I'm a taxpayer, and hence I'm espousing the cause of public. And the Supreme Court started entertaining all these kind of petitions. Was it a welcome step? Yes, could be. In certain cases, most definitely. For example, in the case of the cleaning of the Ganga river, that again was a case which was brought to the court by way of a public interest litigation. So therefore, if one sees that the approach of the Supreme Court in recent times is changing because of the subjects that the courts are being engaged with. In fact, the Supreme Court itself is a little cautious of this. And in a lot of judgments, the Supreme Court does mention this particular aspect. In fact, in a case of P. Ramchandra Rao versus State of Karnataka, the Supreme Court has said this, and I quote, "Though this court does not consider itself to be an imperium in imperio, or would function as a despotic branch of the state, the fact that the founding fathers of our constitution designedly and deliberately perhaps did not envisage the imposition of any jurisdictional embargo on this court, except in Article 363 of the Constitution of India, is significant and sufficient enough, in my view, to identify the depth and width or extent of its powers." In a latter judgment in State of Kerala versus Lakshmakutti, the Supreme Court said, "It is in the above context that special responsibility devolves upon the judges to avoid an over-activist approach and to ensure that they do not trespass within the spheres earmarked for the other two branches of the state." In other words, you will find a plethora of case law on this. You will find several judgments from time to time, even unto this day, where the Supreme Court is conscious of this fact. And this is witnessed time and again. Why is this so? Because the judges should not enter the fields which are constitutionally earmarked for the other two organs. That is the basic premise. The Supreme Court recognizes this. It's manifest in form of so many judgments. Judges cannot be lawmakers. Let's be very clear on that. They neither have the mandate of the people, because that mandate is given to the parliament. Judges are not elected. They are appointed by a mechanism. So they don't have the mandate of the people, nor do they have the practical wisdom that is needed to understand the problems of different sections of the society, which the Constitution says is better understood by the legislature, because that is, the parliament is the elected body. They are the ones who decide. They come from different sections of our country and they sit in the parliament and then they legislate. So they are expected to know the problems better. Judges are forbidden to accept the role of administrators, as this was never the intention of the constitutional makers. So many a times we notice that while interpreting the Constitution, the judiciary sometimes rewrites a particular, if I may, not rewrites, let us use the word interprets it in a particular manner without explicitly saying so. And unfortunately, can have sometimes an undesirable result, wherein individual views or opinions of a judge can percolate into that particular interpretation. And then that becomes the law of the land, because then that becomes binding. So this transgression is the thin line. And this is something that the judiciary has to be careful about. Why do I say the judiciary has to be careful about? Is because, as I said, it is the only organ which can examine the action of a legislature and the executive. It is not the reverse. The legislature executive cannot examine the action of judiciary. If a judgment is wrong, it can only be corrected in a court of appeal. Supreme Court judgment given today may be overturned by a larger bench tomorrow. So it can be done only by the judiciary. Others cannot do it. Of course, you can have legislations which upset a particular law, but then that again is such susceptible to judicial review, and that can again be challenged. So this tendency to enter into somebody else's department is where the friction starts, and that's the judicial overreach that I'll be talking about. Now, two cases come to my mind straight away, because this has to be understood in the context of a case. If I speak in abstract, it's very difficult to understand. You all must be reading recently about this AGR issue of the telecom industry. That is the issue of adjusted gross revenue. And the matter is currently sub judice. Arguments are over. Supreme Court will pronounce its decision. Now, this all started in 2012 with the 2G spectrum case. In this case, the Supreme Court held that the airwaves or the spectrum is a natural resource. The logic behind that is because the state has sent the satellite into the space, and therefore the spectrum that is emitted, etc., is a resource of the state. And if it's a resource of the state, then it would attract what is called the public trust doctrine. And if it attracts the public trust doctrine, then it must be sold in a transparent manner. You cannot select 5 people and say that, all right, I am allowing telephone distribution to you 5 companies in this country for the next 5 years. That is what had happened. And that decision was challenged. So the Supreme Court said, no, nothing doing. You can't do it. It has to be sold by way of an auction, because auction will ensure transparency. And you cannot allot it to an individual entity, that is a company, at a predetermined price. So while the object was very well intended, in my humble submission, certain ground realities were not envisaged or were not foreseen by the Supreme Court. Firstly, the telecommunication reach in India at that particular stage was still at its very nascent stage. In other words, you had to build a network. You had to build that infrastructure. That infrastructure was not being provided by the government. That infrastructure was to be created by the telephone companies. And to achieve this particular end, or mile network connectivity, a lot of expense was needed. Naturally, only companies with big pockets could bid. And because it was on the basis of auction, you had to give it to the highest bidder. Now, the companies that gave that particular bid, who incurred that particular expense, had to ultimately recover it from somewhere. And that recovery ultimately comes from consumers. So the costs significantly increased. Now, one of the offshoots of that, or rather the additional issue that cropped up as a result of this particular deficit that was there between what was actually sold at a predetermined price and what was achieved by auction, was this adjusted gross revenue concept. The 2G spectrum case, in fact, threw up that idea of a notional loss. So the AGR, which is the adjusted gross revenue, which the telecom companies pay to the government as a fee towards the spectrum, had to be recovered. This was based not only on the revenue sharing model, but due to the notional loss that was suffered, the definition of revenue was amended to include revenue from all forms, not just revenue derived from the core revenue of providing telephony as a service, but other revenues from non-telecom services such as dividends, interest income, sale of assets, etc. Therefore, today these telephone companies are faced with a staggering figure of some 53,000 crores, which they have to pay on or before a particular date. If they don't, they face bankruptcy. Now, I'm sure when the Supreme Court was dealing with the 2G issue, they did not realize it is possible. There's nobody can envisage that these could be the fallouts of it. But this is the, if I may say, the risk of entering into regulatory matters. Now, telephone regulatory matters, it's highly technical. The basis of tariff, what should be a tariff, what should be the tariff per minute, per second, etc. These are all technical matters. So in matters which are regulatory in nature, in matters which are technical in nature, where I believe that we as lawyers do not have expertise, or rather cannot claim to have expertise. So also judiciary cannot claim to have expertise in these technical subjects. One should refrain from entering that particular chamber or that particular arena, because that is exclusively meant for that particular department. They are supposed to handle it. So when you start entering these different areas or different fields, that's when the friction starts, and that's where the executive and the legislature feel that this is a judicial overreach. So I hope I'm able to make myself clear. So while judicial activism is great, so long as it is protecting the fundamental rights of our citizens, whether it's an environmental issue, whether it is a labor issue, whether it is something to do with the citizen, fine. That is permissible territory, the court should interfere. But these highly technical matters, the court, according to me, it's my suggestion, should not interfere, because then it creates all sorts of problems. The other case, which is an interesting case, which comes to my mind, is the case of BCCI. Now, the first case, that is BCCI versus Cricket Association of Bihar, was sometime in 2015. The proceedings were initially initiated in 2015. What had basically happened, some of you would recall, was the basic allegation was that there were information received from police authorities regarding involvement of certain people in fixing of IPL matches. Certain persons were arrested. As soon as that happened, a commission of certain members was constituted by the BCCI. So there were two members, and there was one. There were two members of the BCCI, one independent member, and that commission was constituted. That commission, I think they had two former judges of the Madras High Court and one Mr. Jagdale. Mr. Jagdale retired from that particular commission, and the judges proceeded to carry on the investigation and submitted some preliminary report. Incidentally, that was challenged in the Bombay High Court, where the Bombay High Court prima facie expressed that the probe commission constituted by the BCCI itself may not be legally constituted, but it did not choose to interfere in the matter. That matter was then assailed in the Supreme Court. The Supreme Court, while considering that aspect, decided to constitute a committee. That committee was headed by Justice Mukul Mudgal, who was a former judge of the Punjab and Haryana High Court, and two other members. One Mr. Justice Nageshwar Rao, who is now sitting Supreme Court judge, who was the ASG then, and one Mr. Nilayda. They were supposed to look into these particular allegations. They prepared the report. The matter was again resubmitted to the Supreme Court. Question was about two people, I don't want to name them, whether they were guilty, not guilty, etc., etc. In that second round of litigation, the Supreme Court then constituted what we all famously know as Lodha Committee. And in that Justice Lodha Committee, there were two other honorable judges of the Supreme Court. One was Justice Ashok Bhan and one was Justice Ravindran. About 6 or 7 questions were framed. Now, so long as the fixing of the match, etc., that particular probity one can understand. But the Supreme Court also asked them to inquire and make suggestions as regards rehauling or overhauling of the BCCI. And requested to examine and give certain recommendations. It is in that context that that recommendation came in by way of a report. And then the entire saga started, where those 7-8 recommendations were there. All the clubs in India had to fall in line, etc., etc. Now, by doing this, the Supreme Court interfered in the administration of the richest cricketing body of this country. Now, some of y'all who must have seen cricket in the 1970s, 80s, if you see what were the salaries that were paid to the cricketers then, they were part-time employees of central government or working in certain companies. Their per match fee was hardly a couple of ₹100. Today, the fact that the BCCI is such a rich institution, and the fact that they virtually control the world cricket today, is that they must have done something right in their administration to achieve this particular distinction. Yes, if there is an illegality in it, if there is some match fixing, that's a criminal aspect, by all means go into it. But to say that you shall not do this, you shall not do that. Now, I'll explain this in the context because I was personally associated with this. You see, the cricket club, the Board of Cricket for Control for India has various associations and clubs that are members. The Cricket Club of India is a founding member, that is the CCI in Bombay is a founding member. As you all know, the CCI has the Brabant Stadium, which is the Mecca. Even before Wankhede Stadium came up in Bombay, matches were first held in the Brabant Stadium in Bombay. So it was called the Mecca of Indian cricket. CCI was a founding signatory of BCCI because that was a society which was registered in under the Tamil Nadu Registration Act. Now, one of the recommendations which were made, which affected certain associations, certain clubs like the Cricket Club of India, was that the committee felt that the BCCI is being monopolized by certain institutions. Why? They said that all states must have representation. So each state must have one representation. Why is it that only Bombay and Gujarat or Maharashtra and Gujarat have three representations? See, Gujarat has 3 cricket associations. That is Saurashtra, Baroda and one more. And Maharashtra is Vidarbha, Maharashtra Cricket Association and Mumbai Cricket Association. So they said, look at Gujarat, it has 3. Look at Maharashtra, it has 3 plus CCI, which is 4. And look at Far East states, they don't even have 1 representation. Now the fact of the matter is, we all know that northeastern states don't play cricket. There is no infrastructure in northeastern states for cricket. Cricket is something which primarily started in the erstwhile state of Bombay, which included Gujarat, which is why you have Ranjit Singh Trophy, which is why you have Duleep Singh Trophy. These are the Maharajas who actually started funding these games, and these games were played by them. So naturally the representation on this side was more. And when there is a new state like Chhattisgarh, and you had somebody like a Dhoni who became the captain of India, BCCI gave them money and they built a stadium there. So therefore, to say that you must have state representation, state-wise representation, was, if I may say so, actually doing violence to the structure of BCCI. And the fact that Cricket Club of India did not host the cricket team made it into a recreational club, and therefore they said that now you will not be a founding member, you will be only an associate member. But one has to appreciate that the BCCI was housed in the Cricket Club of India. The BCCI's office was in the Stadium House of Cricket Club of India. it could not set up a competing team with the Mumbai Cricket Association. It could never do it. So this is another example of which, to my mind, is an extent of judicial overreach. And then you had some administrators who were Comptroller, Auditor General of India, etc. They were administering cricket for 2-3 years in our country. One wonders whether they had any idea of what the game of cricket was or what it requires to administer the game of cricket in such a large nation of ours, with so many matches, so much happening. So this is another example, as I said, where the courts should be a little slow in interfering. Sometimes one also notices that there is a likelihood where the court, as I mentioned in the beginning, that if there is a vacuum in a particular area, the courts have even gone to the extent of legislating. So one can argue that, is it correct? Is it right for a court to legislate? But if one goes back to the judgment of Vishaka, where the Supreme Court took a serious note of sexual harassment of women at workplaces, and it held and it said, and I quote, "Each incident of sexual harassment of women at workplace results in violation of fundamental right of gender equality and life of liberty and equality." The Supreme Court lamented that the legislature had not brought about a comprehensive legislation till that particular date. This was a judgment sometime in 97. And it said that in view of the above and the absence of enacted law to provide for effective enforcement of basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly against sexual harassment at workplaces, we lay down the following guidelines and norms specified hereinafter for due observance at all workplaces and other institutions until a legislation is enacted for the purpose. This is done in exercise of the power available to us under Article 32 of the Constitution for enforcement of a fundamental right. And it is further emphasized that this would be treated as the law declared by this court under Article 141 of the Constitution. Now, friend, this was a judgment because the Supreme Court felt it was an unoccupied field. The Supreme Court lamented that the legislature had not made any law on this particular aspect, as if we have any less laws in our country. But this crucial aspect, they had not made law. So the Supreme Court laid down the law. And though this judgment was delivered in 1997, it is a matter of great tragedy that our parliament passed this particular law only in 2013, wherein Sexual Harassment of Women at Workplace Act 2013 came to be passed. So in such a case, can we say that the Supreme Court has transgressed its authority and has gone and legislated? But it had to. It had to by virtue of the plenary power it was given under Article 32 for the enforcement of basic fundamental right of its citizens. So therefore that is permissible. Now, in conclusion, I would like to say that while it is desirable that the judiciary calls upon the executive to perform its obligations and the legislature to perform its obligations within the constitutional framework, it will also be against the scheme and philosophy if the judiciary oversteps into the shoes of the legislature and the executive. So while in cases related to labor policy, environmental issues, which pertain to ecological matters, matters pertaining to police atrocities, etc., one can appreciate the judiciary being proactive, and it will also be welcome. Equally, in areas of fiscal policy, in matters of political policy, political affairs, internal functioning of the government, regulatory affairs, if the judiciary interferes, it may suffer from the vice of judicial overreach. In fact, many a times it so happens that this constant overreaching also weakens that particular organ of the government, because the people who are in that particular organ, they say that no matter what we do, it is going to be questioned in a court of law. So it's better we don't take a decision in the matter, let the court decide. This happens in a practical experience, I'm telling you. The other aspect which I just like to conclude on is that, and this is something that I strongly feel as a litigator, as a lawyer, that I notice that PILs are being misused, and which is why the Supreme Court, after passing this judgment, various high courts have formed their own laws, rules and regulations, where you have to fit the particular format, only then you can maintain a public interest litigation. Many a times, it is the responsibility of that lawyer. When a case comes to him, he must decide. He must take that call, not just because you will have the risk of losing a brief, whether this should really engage the judiciary. Because I find that cases are filed just for the sake, if I may say so, that PIL has lost its nomenclature. It either becomes persecutory interest litigation, where some political party or some opponent wants to needle the other person who's in authority and, keep poking at him and trying to put cogs in the wheel. And the other is publicity interest litigation, where somebody feels that, no, this is the right time. Now let me go and file some petition so that I'll get media publicity, because media is also outside the courts every day. One of our judges had really said it very appositely that you must decide whether you want to be a lawyer in front of television channels or you want to be a lawyer in the court. So these are things that lawyers have to ask themselves, whether this matter is a matter which should engage the time of the court. This is very crucial, because such matters which do not require so much time of the court, you are eating into the time which other matters deserve attention by the court. That is very important. High courts, Supreme Court should be deciding constitutional issues, should be deciding matters of law, should not be deciding what rate a ventilator should be available at, should not be deciding what rate the PP should be available at. I'm saying this in the context of current pandemic situation. I've been noticing on this video conferencing hearings that we have, every day there is some petition pertaining to pandemic. It's a situation which has crippled the world. The administration is trying its best to do whatever it can, but there will be petitions every day on some aspect or the other. Is the court expected to look into all this? Is the court competent to look into it? Aren't you taking up too much time of the court? So these are certain questions that we need to ask ourselves as students of law, as lawyers, before filing these kind of litigations. Finally, you will ask me, what according to you is right? Is judicial activism right? Judicial restraint right? Friends, in conclusion, I must say that this is a gray area. I cannot give a definite answer as to whether judicial activism is right, wrong, judicial overreach is right, wrong. It has to be tested in the facts and circumstances of the case. But I have tried to give you a complexion of the matter. I have tried to give you an argument, both in favor of and against. In which cases judicial activism is permissible, is lauded, and in which cases judicial activism can be construed as judicial overreach. So that has been my attempt, and that has been my desire, and which I try to put it across to all of you all. Thank you very much for listening to me very patiently. I must thank the association, that is PLEA, for inviting me on this great platform where I can engage with so many young lawyers, so many students of law, and I hope I could have added some value to your knowledge and your perspective of judicial activism and judicial overreach in India. Thank you very much.